Welcome to Pennsylvania in Focus. I'm Eliana Kernodle. Today we're talking about a case before the Pennsylvania Supreme Court on the Regional Greenhouse Gas Initiative. Joining me to tell us more about this is the Center Square's Pennsylvania editor, Kristen Smith. Kristen, can you tell us about this case?
Sure, this is a case that's been going on for years at this point, although it could be decades for us reporters who are covering it. The Regional Greenhouse Gas Initiative is one that is meant to reduce pollution across 11 different states. And Pennsylvania is not one of those states yet, although the Department of Environmental Protection under Governor Josh Shapiro and formerly Tom Wolf want us to be. Crucially, the legislature does not want us to be. And the main debate here is that if you enter us into the program, what is going to happen is that polluters, which in their case is energy generators, electricity generators, they will have to essentially pay for the emissions that come from their production. And by doing that, they're supposed to slowly ratchet down what they're emitting into the atmosphere while also, by investing in technology that would help them do that. The reason this program exists is because states are trying to usher in the renewable energy transition, but that is very difficult when we rely so much on fossil fuels. And this is considered a way to help do that. The idea with this program is that by 2040, the participating states, their power generators would be down to zero carbon emissions, which sounds like a really heavy lift. And it is, particularly in a state like Pennsylvania, where we are a huge power exporter and we have a ton of natural gas production. So if we were to enter this program, it is very likely that electricity prices would rise, and that would be terrible. I mean, rise by double digits, 30% in some estimates. And that would be really difficult for consumers to absorb, especially during economic uncertainty. So what's before this case is the question of, does the state have the authority to override what could be a potential tax or is this more like a fee that they are levying that is important because keeping the air clean is more important or is worth risking a rise in utility bills? So that's kind of the central argument. Is it a tax or is it a fee?
And why is the distinction between tax and fee so legally important?
So if it's a fee, then that means that the state has the power to enact it through regulation, because part of the state's argument is that it's a fee, we're collecting it for a very specific purpose, and then we're going to use that money to reinvest back into this program and into our goals of renewable energy transition. But if it's a tax, that is unconstitutional for the state to enact without getting legislative approval first. And legislative approval is going to be essentially impossible, given that our General Assembly is split. Senate Republicans are very much opposed to RGGI. House Democrats are supportive of it. And Governor Josh Shapiro, while he doesn't love the concept of a multi-state program, he has his eyes set on a state-based program that would do a lot of the same thing. So as you can see, Republicans have no interest in getting this particular program, or even really his state-based one, to his desk. It's worth it to them to wait to see how the Supreme Court rules on this issue.
And this week, as they were discussing this, talking to state officials in court, whatnot, what were kind of some of the big points of conversation?
Well, the big point for the state is that not only is this a fee and not a tax, but that they have the authority under the Federal Clean Air Act to do this. Because, as I mentioned before, keeping air clean for residents is above importance of all things. They have the right to clean air. But justices were very skeptical of this. They had a lot of questions because that's a very broad interpretation. And if they can limit emissions from the power sector right now, what's to stop them from going after vehicles and even cows and anything else that emits harmful gas? And so there's not really, the state didn't have a very strong response. It's almost a rhetorical question in that sense. But the attorneys that represent power generators, their argument, and the Senate for that matter, their argument is this is unconstitutional. This is going to impact jobs. This is a policy decision. And so therefore, this should have been decided on by elected representatives. Now, judges did have questions about, in general, if it's a tax or a fee for their perspective. But there was also a lot of conversation about, is entering into this program, does it count as an interstate compact? And this is a little bit convoluted, but it's important to the overall discussion. Are we creating a market for limiting emissions, and therefore the state is entering us into this market without legislative input? Or is it more just an agreement, like a collaboration between states to the end of a goal? The state says it's a collaboration, but judges don't seem to be so sure. And that it could be, one of the justices said, from his perspective, it's akin to talking about selling liquor across state lines. It doesn't make sense. We have a very tight state-run system. So for alcohol. So there's a lot of confusion and concern because we've never been in anything like this program. We don't know what the implications are. And the Supreme Court, it weighs heavily on them because the precedent that it sets really sets the stage for future regulatory authority by the state and for the future of climate policy in Pennsylvania.
Well, Kristen, thank you for your insights on this story. You can follow this story and more at thecentersquare.com.